of the City of Waukesha, sitting as the municipal court for the town of Lisbon. Is now in session. Appearances, please.
Kimberly Kreshak on behalf of the town of Lisbon.
Thank you, sir.
Paul Mosina.
Thank you, Mr. Zina. Mosina.
Yes, sir.
I'm going to try.
Mosina.
Mosina, okay. The matter before the court today is a traffic ticket, a speeding ticket, 19 miles, 49 in the 30, 19 miles over the limit, 4-point ticket with a fine of $119. Do you understand, Mr. Mosina?
Well, sir, I'm not an attorney, and
I understand.
I have a few questions.
Do you understand the ticket?
I have a few questions that I'd like to clarify these proceedings before we continue.
No, I asked you a question. Do you understand what I just said with the ticket?
Well, do I understand? Can you repeat that?
Okay. The matter before the court today is a speeding ticket.
Okay.
Alleging that you were going 49 miles an hour in a 30-mile zone, which is 19 miles over the limit. That is a 4-point ticket with a fine of $119. That's why we're here today. Okay? Do you understand that?
That's the allegation made in the citation. That's what you're repeating. Is that correct, sir?
That is correct.
Okay, there's an allegation on the table.
Okay. Now, before we go any further, I have gone through your file. And in the file, Mr. Mosina, there is a letter from you, a motion from you, an indication from you that previously you wish to withdraw the not guilty plea that was entered on your behalf by Judge K. If you do that, then this court will find you guilty. I will assess 6 points against your driving record and levy a fine of $119 if the matter is stopped. Now, do you wish to proceed with that request that you made to the court?
Let me clarify that, please, sir. You're saying that if I file a motion to vacate the plea that was made by Judge K, then what are the ramifications if I vacate that plea?
I will find you guilty. And the matter will be over.
So if you will find me guilty, is on what grounds, sir?
Sir, when there is a ticket, an allegation, you have to enter a plea. If you don't enter a plea, the court may enter a plea for you. That is by statute.
Okay, so if there's an allegation, I have to enter a plea. All that's required for me to enter a plea is an allegation? Is that what you're saying?
Yeah, they are alleging you did this. If you wish to...
Let me write that down. And please, excuse me, let me write that down. You're saying that if there's an allegation against me, I have to enter a plea.
That is correct. You have to either admit it or deny it.
Let me write that down. If an allegation is made, I have to enter a plea.
You have to either admit it or deny it.
Sir, I'm not an attorney, and can I ask
you... You don't have to repeat that, sir. I'm on the record as acknowledging you are...
I understand.
Please don't waste your time or my time.
I didn't finish my thought, sir.
No, I'm finishing your point. You're not going to ramble.
I'm not rambling, sir.
Yes, you are.
Sir?
You are rambling. Now, I am stating the fact. There is an allegation here. A ticket has been issued. You either have to admit it or deny it. If you deny it, the matter will go to trial.
So, does the court have to have jurisdiction in this matter?
The court does have jurisdiction.
And, sir, is there evidence that the court has jurisdiction?
Yes.
What is that evidence, sir?
The Wisconsin state statutes, which adopted from the state constitution, which is adopted from the land ordinances of the Northwest Territory, which created the territory of Wisconsin, which was acknowledged and and Wisconsin was admitted to statehood in 1848 under the auspices of the United States Constitution, which was entered on September 17, 1786, which adopted from the Declaration of Independence, which was on July 4th, 1776. I have read all of your briefs, sir, and I have researched them all. And that's the status of the law to which you are subject to as a resident of the state of Wisconsin, which you have acknowledged in your briefs.
Let me just write that down a second. You're saying that I acknowledge that I'm a
You can
state...
order a transcript of what I have said.
Sir, I don't want to proceed if I'm not clear on what you're saying. I'm just seeking
You are going to
clarification.
proceed. I'm going to proceed today.
I'm seeking clarification of what you're saying. Are you saying that it is your opinion, is that an arbitrary opinion, that the state...
Absolutely not, sir. My opinion is based on the laws of the state of Wisconsin.
And what facts, sir, what facts and evidence do you have? What facts who has the burden of proof? Does the prosecutor have the burden of proof here today?
Burden of proof for what, sir? I have
Jurisdiction,
I have
sir.
stated that I have jurisdiction. If you don't want that jurisdiction, you may move. You may challenge the jurisdiction. I have made the ruling. I have jurisdiction. Now, you
Sir,
proceed.
do you have any facts and evidence to back that up besides just your opinion, sir?
I have the state constitution of Wisconsin.
And what facts associate me with the state constitution? When and where and why did it become applicable to me, sir?
You're a resident of the state of Wisconsin. You acknowledge that in your writing.
Sir, I made no such acknowledgement.
Yes, you did. We're going to proceed.
Sir.
I'm not going to sit here and argue with you, sir. I have stated the facts.
I'm not arguing, sir.
Yes, you are.
I'm simply asking for you to present the facts and evidence that your codes and statutes apply to me. When, where, and how did they become applicable to me, sir?
Are you a resident of the state of Wisconsin?
I'm not here to answer. I'm not here to defend myself and answer your questions. You have to present evidence of that, sir.
No, I don't. No, I do not.
So let me write that down. You don't have to present evidence to back
I
up your
have to
assertion?
present evidence that I have jurisdiction. I have jurisdiction because I am an elected judge by the people of the state of Wisconsin.
Okay. And what facts and evidence apply to me as a non sequitur?
Sir, you don't understand. You're not an attorney. You don't understand. I suggest you get an attorney.
If I got an attorney, would you do what the attorney said? If I hired an attorney, would you do what that person said?
I would listen to the attorney, but the attorney would not be trying to make the arguments you are.
Sir, I'm asking clarifying questions. I'm asking you for evidence that associates me.
I have to provide you with any evidence other than the fact that I am an elected judge in the state of Wisconsin, subject to the laws of the state of Wisconsin. You have acknowledged that you are a resident of the state of Wisconsin. You have acknowledged that by the fact that you have a driver's license in the state of Wisconsin. You are subject to those laws. End of discussion. Now we're going to proceed.
Sir, excuse me, sir. I got a driver's license because I was under...
You have a driver's license in the state of Wisconsin?
I got a driver's license because I'm under threat, duress, and coercion. If I don't get a license, then someone's going to pull me over and harass me. I didn't get a license because I wanted to.
Driving is a privilege, sir. It's not a right. It's a privilege. And you have subjected yourself to the laws of the state of Wisconsin traffic law. Now we're going to proceed.
Sir, I have many motions on the table. We're not ready to proceed, sir. I have motions on the table.
We are ready to proceed. Don't you tell me, sir, that I am not ready to proceed. I am ready to proceed.
Does it matter if I'm ready to proceed, sir?
Yes. Yes, it does, because you were notified today. We're here, 10:30. We're here. You were notified. You are ready to proceed. If you're not ready to proceed, we're still going to proceed.
Sir, what am I proceeding with?
I'm proceeding with a trial. I asked you if you wish to withdraw your not guilty plea. You have failed to answer me. Therefore, I am conducting a trial.
I did not say...
Be quiet.
Sir, I did
Be
not...
quiet. We are proceeding to trial.
Sir, is it safe for me to...
Would you be quiet? We are now proceeding to trial.
I object, sir. I'm not ready to
I don't care
proceed.
if you object or not. It's overruled. Mrs. Kershak, there are motions on the table. Motion to vacate a not guilty plea. That has been handled. Mr.
Sir, I understand, this is not, the mind talks about fair and
I'm going to
reasonable.
find you in contempt of court. If you keep interrupting me,
It is
now be
not safe for
quiet.
me to speak.
Be quiet. The motion to vacate a not guilty plea, I have addressed that with Mr. Messina. He has indicated to me that he does not wish to proceed. That motion is denied.
I have to disagree with that, sir. I believe
We have a
that.
motion to strike or dismiss the citation. That is denied.
But on what grounds, sir? Is that an arbitrary opinion? Can you cite the legal grounds for which you made that denial, sir?
There is a motion to strike or dismiss the complaint for prosecutor misconduct. That is a matter that will be handled by the Board of Professional Responsibility. The court finds nothing in the record or in the indication from Mr. Messina that there has been any prosecutorial misconduct. So that is dismissed also. There is a motion to rescind Judge Hausman's orders. Judge Hausman's orders have no effect in this court, and they are not being considered, and that motion has no merit, and that motion is dismissed also. We are now going to proceed on the trial.
Sir, do I have the right to plead guilty here today, sir?
Huh?
Do I have the right to plead guilty here
Yes, you
today,
do.
sir? Do I still have the right to
Yes,
plead
you
guilty?
do. Do you wish to plead?
Do I have the right to make an informed plea of guilty here today, sir?
What?
An informed plea of guilty here today, sir? Do I have the right to make an informed plea of guilty here today, sir?
Yes, go ahead. I'll accept your guilty.
Do I have the right to be informed of the nature and cause of the proceedings here today, sir?
You have that. You have the ticket.
And on the ticket, where is the evidence that the codes and statutes of the state of Wisconsin apply to me on this ticket, sir? I have a copy right here. Can you show me where on the ticket is there evidence that the codes and statutes of the state of Wisconsin apply to me?
It has your name, it has your address, it has the ordinance that was violated, 4201. It was delivered to you in person. It states specifically that you were exceeding the speed limit of 16 to 19 miles per over by going 49 in a 30, which is 19 miles over the limit. That is in,
Sir, you're reciting what's on the allegation, sir. I'm asking if there's facts and evidence on the citation that proves... sir, I'm challenging the court's jurisdiction.
you don't have any right to the court's jurisdiction. I have stated.
Excuse me, sir. I don't have a right to challenge the court's jurisdiction. Let me write that down. I don't have a right to challenge the court's jurisdiction.
You have challenged jurisdiction. I have ruled this court has jurisdiction. That matter is now closed.
And what facts and evidence did you bring to prove that, sir?
You wish to proceed?
Yes, sir.
Please call your first witness.
The city calls Deputy O'Toole.
Deputy O'Toole.
Sir, do I have a chance? I would like the chance to voir dire the witness, please, sir.
You will, sir. We're conducting a trial.
I would like to voir dire the witness before, to establish the competency of the witness. I would like to voir dire the witness before he begins his testimony. Otherwise, we can't know if this person is competent to testify on the matters before the court today, sir.
Your request is denied.
On what grounds, sir? On what grounds do I not have a right to check the competency of this witness? This is the state's witness against me, sir, is it
You
not?
have the right in cross-examination, sir.
Before this person's testimony is put on the record, sir, don't I have the right to establish whether this person has competency to speak about these matters here today, sir?
No.
Okay, let me make that down. I don't have the right to inquire into the competency of the deputy.
Sir, please, I want to tell you something. If you keep interrupting the court, I'm going to hold you in contempt. You can write down anything you want. I am on the record. The record will be provided to you. I don't care what you write down. I really don't care what you write down, sir. It's of no consequence whatsoever to me. It's not in evidence, and if you want to enter it later, when it's your turn to enter your evidence, you may do so. Please proceed.
Deputy O'Toole, could you please state your name and spell your last name for the record?
Alex O'Toole, O-T-O-O-L-E.
And how are you employed?
Patrol officer with the Wash
How
So
long,
speak up, please, and speak into the microphone.
how long have you been employed in that capacity?
Be about 2.5 years.
Were you on the duty as a Waukesha County Sheriff's Deputy on January 16th of this year?
Yes, I was.
Do you recall the hours of your shift that day?
Yes, I was from 2:45 to 11 p.m.
What were the nature of your duties during your shift that day?
I was on patrol and just looking for traffic violations.
In your employment with the Waukesha County Sheriff's Deputy's Office, do you have a specific role that relates to the town of Lisbon?
Yes, it was. I'm the contract deputy for the town of Lisbon.
Can you explain what that means exactly?
Every day I work for the town of Lisbon in that area of the town of Lisbon.
Do you recall where you were located at approximately 6:48 p.m. on January 16th of 2015?
Yes, it is. I was up on County Line Road near Colby Road.
Is that location within the limits of the town of Lisbon?
Yes, it is.
While in that location at that time, did you observe the defendant operate a motor vehicle?
Yes, it is.
Where was the defendant when you first saw him?
He was on County Line Road traveling eastbound.
And where were you located when you first saw the defendant?
I was also on County Line Road. I was running stationary radar.
And what, if anything, drew your attention to the defendant's vehicle?
I know that he was traveling at a high rate of speed.
And was that based on your own observation or based on a reading from the radar?
On my own observations, and then when I turned on my radar, it validated my observations.
Objection, calls for legal conclusion.
Overruled.
On what grounds, sir?
Overruled.
Do you test that radar machine before using it?
Yes, it is.
How often do you do that?
Before I go out on patrol, and then after every stop.
How do you test the machine?
An internal test, and then an external test with the tuning forks.
Can you explain briefly how you test it with the tuning fork?
We have 2 different tuning forks. You hit it, it makes a tone, you put it in front of the radar, and each tuning fork has a different speed that it should be at.
And did you test the radar machine that you were using that day prior to your shift?
Yes, it is.
And did you also test it again prior to the stop of the defendant in this case?
Yes, it is.
Was the machine working properly during those tests?
Yes, it was.
Did you test the machine again after your encounter with this defendant?
Yes, it is.
And was it working properly then?
Yes, it was.
You said that the radar confirmed your suspicion that the defendant was traveling at a high rate of speed. What did the radar tell you?
It clocked him at 49 miles an hour and 30 miles an hour.
Is the 30 mile an hour limit posted in that particular area?
Yes, it is.
Do you know where it is posted in relation to where you and the defendant were located?
It would have been, he would have passed the sign already by the time that I had clocked him on radar.
How did you know that the radar was giving you a valid reading?
Gave me a clear audible tone with no interference.
If there had been interference, what would it sound like?
The tone would have been choppy.
Do you have any reason to believe there was any other vehicle in the radar beam when you received the reading of 49 miles per hour?
No, the defendant was in the vehicle at the time.
Based on your observation, what did you do?
After he passed me from where I was sitting on the side of the road, I then conducted a traffic stop.
Objection, calls for legal conclusions.
The
Objection.
officer can testify what he did.
It calls for legal conclusion. He decided that he
It's
was...
not a legal conclusion, it's an issue of fact, sir. He stopped you.
Based
got
on
a
what,
reading?
based on what grounds, sir?
He got a reading.
Based on his legal conclusion, sir?
No, not on a fact. A legal fact, overruled.
Deputy O'Toole, do you recall any description of the defendant's vehicle?
It was a black truck.
When you pulled out, did you activate your licensed veteran?
I first ran the defendant's license and activated my license.
Did the defendant pull over?
Yes, he did.
Did you make contact with the person who was operating the vehicle that day?
Yes, I did.
And did you identify yourself to that person?
Yes, I did.
Did you tell the person why you stopped him or her?
Yes, I did.
What did you say?
Yeah, that goes to the Washington Sheriff's Department, reason stopping me today. My pocket full of $10 very long, so.
Objection. Calls for legal conclusion.
Overruled. Statement of fact by the officer.
Were you able to identify the driver?
Yes, I did.
How did you do that?
The Wisconsin full driver's license.
And the person that you identified as the operator of the vehicle that day present in the courtroom here today?
Yes, he is.
Where is he located?
Sitting to my right, in a short sleeve t-shirt and a tie.
Well, let the record reflect that the deputy has identified the defendant as the driver that day.
It's true. Muzina, do you have any objection?
I certainly do, sir. I have many questions for the deputy. May I proceed?
No. Mr. Muzina has not indicated any objection to the officer identifying him. The record will so reflect that the officer has identified Paul J. Muzina as an individual and he stopped on the date and time in question. Proceed, officer.
Did the defendant make any statement to you during your initial contact?
Yes, sir.
What did he say?
Stated that speed limit signs are optional and that you committed a crime.
How did you respond?
Objection, sir. I never said that the speed limits were optional. Speed
Sure,
limit
you'll
signs
have
were
an
optional.
opportunity to cross-examine the witness.
And did you make any response to his comment?
You stated that the speed limits are not optional.
And what happened next?
At that time, that's when I got his driver's license and went back to my car.
And then what did you do?
I ran into my in-squad computer and issued a citation
What was that citation for?
for speed limit 16 to 19, which I issued to him.
Objection. Calls for legal conclusion.
Overruled. Sir, you don't understand what a legal conclusion is. You may make those objections, they will be overruled because they have no basis. Proceed.
I'm sorry, I think I asked you what your decision to make the issuance of the ticket was on.
Officers asked that.
Okay. And did you then give the citation to the defendant in person?
Yes, I did.
Did you make any additional statement to the defendant at that time?
I just I issued and explained the citation to him.
Did he make any comments to you?
He became very argumentative, saying that I didn't have jurisdiction over him. He wanted proof of that.
So how did you proceed from there?
Basically, we came into a verbal argument, which I stated that he would have his time in court to argue that fact. And then he took off.
After that, on the day of the stop, did you have any further contact with the defendant?
After the stop?
Correct.
Okay.
I have no further questions for the deputy at this time.
Thank you.